Aloha, this is Professor Porter. We're talking about the Federal Rules of Evidence. We're into hearsay, and specifically we're into the 803 reliability exceptions. Today we're talking about statement for purposes of medical diagnosis under 803.4. And just remember the larger landscape here that essentially the opponent always says the same thing. They always have the same initial response to a hearsay statement that's said in court. They want to say objection hearsay, and that's because they're embracing the definition of hearsay under 801C, out of court statement, truth of the matter asserted. The proponent's the ones with the option. The proponent, the one that was putting on the testimony, the one that was likely eliciting from a witness an out of court statement, then has some options. They can argue the nah of that hearsay definition under 801C. They can argue their own definition of not hearsay under 801D for prior inconsistent statements, prior consistent statements, out-of-court identifications, or statements made by or attributed to parties offered by party opponents. And lastly, in a checklist type of way, the proponent can go to the wonderful world of exceptions. And the first batch of exceptions that we cover is under 803.3, and it's because the rule makers have said in these narrow circumstances that surround this statement and include the content of the words within that statement, they've determined that the circumstances make it reliable enough. We can trust what's said. We don't need to meet that declarant. We don't need to have the underlying policy of hearsay met where we cross-examine a declarant or have the jury evaluate the credibility of a declarant. So statements made for purpose of medical diagnosis, I think, is one of the most clear examples. And if you think about the arguments that we make as proponent, I might say, this is not hearsay. It's not offered for the truth of the matter asserted, Your Honor. Instead, it's offered for some other purpose. If it's an 801D situation where I have my own definition, I might say this is not hearsay defined under 801D because it's a prior inconsistent statement, because it's not of court identification, and I go through that argument. And lastly, if I'm the proponent and I've gone through this kind of checklist and I've got my way down to just these narrow patches of circumstances that have to do with reliability exceptions, I'm going to say, Your Honor, it may be hearsay, but an exception applies. Specifically, this is a statement made for purpose of medical diagnosis under Rule 803.4, and then I go forward with my argument. Here you see the popular hearsay exceptions under 803 that we cover. Statements made for purpose of medical diagnosis, I think, is the one that is titled the best, because if you remember the title, you pretty much remember what the rule is about. I've already said in other videos, I'm not a huge fan of the title present sense impression, because you really got to think of that reporting, that real-time spoken observations. Excited utterances, I just hate the use of the word utterances there. They're really excited statements, that exclamations that you can hear that are about an excited event while you're still excited from that event. State of mind even is more limiting in its title and its language, because it really has to do with physical, emotional, anything that's going on with you, any then existing sensation that's going on with you at the time, to include your intent or motive or design to do some future act. So state of mind is really limiting. Remembering state of mind, you only remember a fraction of the rule. Statements made for purpose of medical diagnosis pretty much is what it is, as we'll see. And here's the balance of the rule, which you can imagine. It's statements made for purpose of medical diagnosis. That's kind of what the rule is. And it gives some examples describing medical history, describing your present sensations and pain. And you understand just reading this rule, what's the policy behind it. This is the clearest articulation of policy, really, if we think about it, because the policy here is we trust when you're talking to a doctor, or when you're talking in the direction of providing someone information to provide medical treatment to you, even if I'm saying it to my wife to be relayed to a doctor, even if my wife's talking to someone in the ambulance, if it's in the direction of for purposes of medical diagnosis and treatment, we're willing to buy that. There's an independent reason why that information should be trustworthy. We want to try to. Does that mean it's guaranteed trustworthy? Of course not. We have doctors and people associated with treatment and medical diagnosis that ask us questions we give less than truthful responses all the time. But we're willing to say that because it's independently trustworthy, because we have a reason outside of this court proceeding for trusting in that statement. And of course it has to be pertinent. It has to be related to the diagnosis and treatment. Just because I'm talking to my doctor and I say, were you able to see the Patriots game this past Sunday? That statement is made to a doctor. It's just not for the purpose of medical diagnosis and treatment. It's not pertinent to my diagnosis and treatment. And you can imagine why, as we discussed, why sincerity and reliability is enhanced. You can imagine declarants can be the patients or others. You know, if I'm in a car accident, I'm giving a thumbs up or I'm pointing to things, maybe someone else is doing the talking for me. So don't limit it that it has to come from the patient. And the statements are made to medical professionals or anyone that's going to relay it to a medical professional. So if I say it to the EMT, if I say it to the nurse, if I say it to the person who's at the counter when we get in, that I have a burning sensation or a rash that goes up my arm or I'm feeling dizzy, those statements are made to get medical diagnosis and treatment. Don't narrow it to confine it to have to be to the doctor themselves. So here we have a couple of examples that highlight some of the interesting parts about 8034 statements made for purposes of medical diagnosis. Obviously, top left, doc, my throat has a burning sensation. That is a statement that's made for purposes of medical diagnosis. It's clearly pertinent. Objection hearsay. This is a statement made out of court from patient to doctor. Witness is someone else other than the declarant patient. But this is going to be, Your Honor, while it may be hearsay, an exception applies. Statement made for purpose of medical diagnosis under 8034 because this was a statement made to the doctor for purpose of medical diagnosis and it's clearly pertinent to the diagnosis and treatment. If you go around to the right, 911, my husband collapsed in the backyard clutching his chest. So notice here the declarant is not the patient. It's the wife of the patient making a call into 911. And notice that the person that the wife's talking to is not the doctor. They're talking to 911, but you can imagine the arguments that can still be made. This is the wife's statement. The wife's the declarant, but she's making it for the purpose of medical diagnosis and treatment of her husband's injury. And even though she's saying it to 911, she's saying that for the purpose of medical diagnosis and treatment so they can convey to the ambulances and EMT to come out there. So I think even that one, although not a patient declarant and not said to a doctor, that highlights how broad the rule can be. Just think about these things. They can also be, they don't have to be like 8031, present sense impression, 8032, excited utterance, 8033, state of mind. They don't have to be current statements, right? They can talk about yesterday my throat started hurting. My throat's been having this burning sensation for a few weeks, doctor. So it can be past looking. We appreciate the sincerity and the reliability of a conversation we're having with a doctor, particularly for the purpose of getting help, for getting treatment, for getting a diagnosis. Doc, I was hit with a wrench in the pelvis. Now, this is getting kind of closer to the facts of the case. Imagine it was an assault and it was assault with a wrench, and the statement's going to help the prosecution in this assault because we recovered a wrench and we know the person had a wrench or we have fingerprints on a wrench, but we independently evaluate the circumstances surrounding the statement. This is a patient talking to a doctor saying exactly what happened to them, that they were hit with a blunt instrument. That's going to help with the diagnosis. That's going to help with the treatment. And there's at least a really good argument to make that, Your Honor, while this might be hearsay, an exception applies under 8034, statement made for purposes of medical diagnosis, because this statement relates what happened, where he's hurting, how he got hurt, what he was hurt with, such that it can lead to a more accurate and more effective diagnosis and treatment. On the bottom, Doc, I was hit with a wrench by Jonathan. The by Jonathan part is going to be the real problem. It's going to be the fight here. You might still need to say to a doc that you were hit by a wrench, a blunt instrument, such that it could lead to diagnosis and treatment. The identity of who did it, that's really for litigation purposes, not for medical diagnosis. So what would happen with this statement, like we see with many hearsay statements that are argued and become the subject of an evidentiary discussion, it's probably doc, I was hit by a wrench is going to be admissible under the hearsay exception on 8034, statements made for purpose of medical diagnosis, and by Jonathan is going to be redacted or omitted because that's pure hearsay. It's the same thing as saying, this person said outside of court, this patient said outside of court, Jonathan's the one that did that to me. If that person's not here, it might not have any hearsay explanation. It might just be pure hearsay that should be kept out, and we want the first-hand account. And then lastly, the one that's in the middle and left, doc says, get some rest and get back in 2 days. And sometimes students and those new to essay, new to evidence get turned around by this. But, that is the diagnosis. That is the treatment. So that's a little different than a statement made for purposes of the diagnosis and treatment. So this could be legally operative language if the diagnosis is important in some way and it's subject of a an expert's opinion or part of a medical report. But the doctor's statement, if the doctor's not there, is likely not going to qualify. These are statements made by others in the direction of diagnosis and treatment. And again, it doesn't need to be by the patient as long as it's in the direction of purpose and treatment for the patient. And it doesn't need to be to the doctor. Again, so long as it's expected to be relayed.